Sorry, guys. Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us as we are continuing our coverage, Super Bowl, continuing our coverage of California versus Carlos Dominguez. And no verdict yet. No verdict yet. We are in verdict watch. Verdict watch still. Ooh, are you guys talking about tzatziki? We call it chichiki around these parts, but tzatziki, yeah, I just made some over the weekend. I make it like every weekend, basically. That's some good stuff, JWD. All right, we are in, gosh, what day are we in? Day 27. So they started last Friday. They went Monday, Tuesday, Wednesday. They took off Thursday, and then they also took off Friday. So we are in day 3 full days. Let's see, I'm sorry, Wednesday. Yeah, so Monday, Tuesday, and Wednesday were full days. Friday was like 15 minutes. And then today they've been going, I believe, since 9 o'clock. So, oh, Newton, there you are. Yes, the jury is unionizing. This is insane, right? What is going on with this jury? Well, we do know. Hold on a sec. We do know that they had a jury question which we played. Here, let me go over here. Sure they're there. I think today they're there because Newton is in our chat and he told me yes, we've been in communication that they are indeed there. At least we're hoping. Oh, here, let me pull myself up. Where am I? And while we wait, might as well let's look at something fun. All right. Watch the little kitties while we wait. We did watch the closing arguments on Monday, and then also, we watched the closing arguments yesterday. Or no, what's today? Monday? Friday, I guess. We watched them Friday. And we watched, we know there was a jury question. It was about instruction 600. They were still, meaning the jury was still going over testimony for Dr. Vinson, I believe. And Dr. Vinson was the one, was she the psychiatrist? Hold on a sec. She was the psychiatrist. So she was the psychiatrist that was brought in by the defense. Everybody else had been court appointed. She was the psychiatrist that was brought in from Georgia, I think Atlanta. Pretty sure that's where she was from. So they were reviewing her testimony on Wednesday when they had that jury question. So just so you guys know. All right. Let me go to my notes here, pull up our notes. All right. Psychosaurus, yes. Thursday. I'm going to go to the P.O. Box on Thursday, and we'll do an unboxing on Friday. So I go like once a week. So I'll go on Thursday morning. I'll head over to the P.O. Box, and then I will we'll do an unboxing on Friday. Newton says would be really weird for a hung jury. Agreed. Hey Holly, how are you? Good to see you. Thank you for joining us. Marty says, what was the jury question? Hold on, I'll get to that in a second. Baca, 2 full days off in the middle of deliberations. Yeah. Well, let me play it since we have time. Let me go ahead and play it. Let's see. Hold on. I'll play it again because we have time. let's see, this was day, I think it was here. Okay, that was replay of closings. All right, hold on just a sec. Okay. All right, let me play. For those that missed it, this is, oops, hold on. This was the question on Wednesday, last Wednesday. All right, hold on a sec. Can we just pull this up?
At the bottom of the tree.
All right, hold on a sec.
And under the cherry moon.
All right, so this is from Wednesday.
Murder requires a plan. They underlined the first two sentences of the instruction paragraph that discusses what a direct step is, one that goes beyond a plan. So then, in looking at this, any comments by the prosecution?
I think the jury needs to be referenced back to that definition, but it encompasses it's more than a plan or preparation, because they mentioned it does have to have a plan, but it's an or in the CalCrim, so it doesn't have to necessarily be a plan that's articulated. It can be other steps as well. So I think those two things need to be highlighted, and it doesn't need to be, or it would be inappropriate to just reference one in isolation.
Okay, to make sure I'm understanding, you're indicating that the court should advise the jury that CalCrim 600 is an accurate statement of the law, and as to the question whether a plan is required, the instruction indicates a plan or preparation.
Correct.
Okay, all right. Mr. Hutchinson.
I disagree with the people. I don't know how the court could clarify it any more than the instruction states. I looked up the case law. This instruction is taken directly from case law. An attempted murder requires a direct but ineffective step toward killing another person, and a direct step is defined. So I asked the court simply to refer them back to instruction 600.
Right. The direct, what's the argument here as to the direct step? I mean, the direct step is thrusting a knife into the backside of Kimberlee Guillory. That's the direct step, right? I mean, the defense claim and fight here is all about specific intent to kill a person.
Yes, but I'll be honest, I don't fully understand this question, but you never know what a jury will be discussing. So I think, but I don't know how the court could answer beyond referring it back to 600. Element one is at least one direct but ineffective step toward killing another person, and a direct step is defined for them, and that's straight out of case law.
It is. I mean, there's a lot of cases that you can imagine the direct step. You know, someone's got a gun there and pulls the trigger and the gun jams, you know. The interesting thing about attempted murder is it's an express malice crime. Requires specific intent. You can't get it through conscious disregard.
That is correct. Requires a specific intent to kill.
Right, right. And so, and then we gave him the instruction, which really my summary of attempted murder is it's not divided in first and second degree, although the court looks at premeditation when it sentences. That's my understanding of it, and that's why we gave him a verdict form on, in effect, what's an enhancement. All right. I think it's frustrating sometimes, because all you can really do is turn them back. And I think I'm most comfortable with just advising them that CalCrim 600 is an accurate statement of the law of attempted murder. And I'm comfortable with that. Okay, so I appreciate that. I appreciate everyone coming here. I can give you a summary of what I understand. The readback took place yesterday and then today, as requested, as to the segments of the doctors. And then I think it finished. Well, they did readback all morning, and they have a little bit more of Dr. Vinson's testimony, not much, and the jury interrupted that and wanted to discuss the status of their deliberations before calling the court reporter back to finish the reading of Dr. Vinson. And so that's the status of the readback. And I don't have any indication about when or if they will call the court reporter back, but it was interrupted, and then the next thing I know is I got this note. So I'll prepare an answer right now and get it to him. Okay. Anything else?
Other than thank you for letting us be dark tomorrow. Nothing further.
Right. Yes. Exactly. My hope is that that we'll get a verdict and we'll announce it on what's today, Wednesday. So we announce it on Friday, and then I can meet with the jury and plan it. My hope is I'm given enough notice that I can get the alternates in too, and so I have them here for the reading of the verdict, and then we would start testimony with Dr. Vincent on Monday. But that depends on whether they have a verdict for me by Friday. All right, so we are dark. This case is dark tomorrow. Thank you.
So clearly that didn't work out. Clearly that did not work out. So that was from last Wednesday. And you heard him say he was expecting. So they were listening to Dr. Vinson's playback, right? So that means that was the psychiatrist that the defense actually hired, that was not court appointed. So they were listening to the playback. And the judge was expecting, well, they were dark on Thursday because they had already asked for that, Baca. They had asked for that, I think, a week or so before, but they didn't know about Friday being off. They didn't know about that. At least we didn't know about that. Yeah, Newton, this is crazy, man. So all we do is just we sit and wait. It's 12:30 out there where you are. Let's hope they can get a I'll just play some music. Yeah, no. That was last week. You guys. That was last Wednesday. So it was Thursday of last week that we knew about, and then Friday we didn't know about. At least I didn't know about it. So yeah, that was last week. That was last Wednesday. I just wanted to play that because that's the one and only jury question that we heard. Hey, Golden Girl, you've been here. Just can't type too much because your hands are so bad with carpal tunnel. Aw, sorry, Golden Girl. Sorry to hear that. Thank you for joining us, though. Move us over here. So we wait. I played closing arguments on Friday, and we're just Golden Girl, how are you? And you're welcome. Sorry to hear about your carpal tunnel. That stinks. Yeah, so I played closing arguments on Friday, and we're just here waiting. I may go through a load of laundry and I'm gonna go through a load of laundry. And Newton, if a verdict is announced, let me know. I'm gonna go do a load of laundry.
There's nothing left to get back home to, so take the first bus in the station. Everywhere is nowhere to lost souls. Let's get lost by intention, where the world has protection, where the waves hit the sand. Naked bodies in the sun, scattered lips, arms and pebbles, sinking slowly as the mud at the bottom of the ocean. We're all light and emotion, drifting without a sound. Me and Mary and I walk into her room, through lonely streets at night under blood cherry moon, till we hit the ground. Lay upon a shallow part of her dreams, late in the morning, smell of coffee and of silent fiends, slowly are morphing, the recollections of drowning in each other's arms. Me and Mary and I walk into her room, through those lonely streets at night under blood cherry moon, till we hit the ground.
All right, so you wanted jury instructions. So let me find jury instructions. This is right after closing arguments. All right, this should be right after closing arguments.
He is guilty. Thank you.
Okay, thank you, counsel. That concludes the people's final argument, and that concludes the closing argument phase of this jury trial on this Friday at 4:10. And so now I'm going to read to you CalCrim 3550, and I'll remind you that I will have these instructions copied for you. Ladies and gentlemen of the jury, when you go to the jury room, the first thing you should do is choose a foreperson. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide this case for yourself, but only after you have discussed the evidence with other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you. Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please.
Okay, I actually found that's not the full jury instructions. Hold on. I actually found them. They're at the beginning. Sometimes they're at the end. Sometimes they're at the beginning of closing arguments.
When we start them in just a moment.
All right.
This is a three-step process.
Pretty sure this is it.
We'll go first. The defense will go second. And then because the people have the burden of proof at this stage of the trial, they have a final argument. So 1, 2, 3. But first, legal instructions. All right. And I think I'm probably going to tell you more than once, but it's a stack, maybe 30 or 40 pages. You're going to get a copy of these instructions in the jury room, okay? So when I'm reading them to you right now, it may be a lot of information coming at you, all right? The lawyers are going to tell you what they think the facts are based on the evidence and how it applies to these legal instructions, okay? But you're going to have a copy of these. I'll make as many copies as we need for the jury room, all right? Do your best to follow along. It's not like reading a book to your children. The Judicial Council has drafted these. I've modified some of them, but they're still in legal language. All right, so just bear with it. You're going to be able to work through these. All right, let's get started. Each of them has a number that relates to the Judicial Council standard form. This is CalCrim 200, members of the jury. I will now instruct you on the law that applies to the case. I will give you a copy as indicated to use in the jury room. You, the jury, must decide what the facts are. It's up to all of you and you alone to decide what happened, based only on the evidence that has been presented to you in this trial. You must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. Many people have assumptions and biases about or stereotypes of other people and may be unaware of them. You must not be biased in favor of or against any party, witness, attorney, defendant, or alleged victim because of disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. I will address implicit bias in a moment. You must follow the law as I explained it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions. Pay careful attention to all of these instructions. Consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use.
These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary, everyday meanings. Some of these instructions may not apply depending on your findings about the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you have decided what the facts are, follow the instructions that do apply to the facts as you find them. So for the next about 10 minutes, I'm going to read general instructions, and then I'm going to get to the specific charges, okay? So these are overall general instructions to start with. Calcrim 201, and you've heard this before, do not use the internet, a dictionary, a logbook, or medical book, or any other source of information in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case, either on your own or as a group. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you happen to pass by the scene, do not stop and investigate. Imagine 100 years ago, you go into the jury room, you wouldn't be able to investigate and so forth. Nowadays, with your iPhones, you could start Googling anything or searching for anything. So don't do that. You should turn your phones off and then agree as a jury, hey, we're going to, every half hour or whatever time period is appropriate for you, we'll allow a short break to check on whatever, an hour and a half or whatever time. But turn the phones off while you're deliberating. And obviously don't use them for this case. Calcrim 202, you've been given notebooks and may have taken notes during the trial. You may use your notes during deliberations. Your notes are for your own individual use to help you remember what happened during the trial. Keep in mind, your notes may be inaccurate or incomplete. If there's a disagreement about the testimony and stipulations at trial, you may ask that the court reporter's record be read back to you. It is the record that must guide your deliberations, not your notes. You must accept the court reporter's record as accurate. Do not ask the court reporter questions during the readback and do not discuss the case in the presence of the court reporter. Please do not remove your notes from the jury room. When you take your notes into the jury room, leave them there. At the end of this trial, your notes will be collected and they will be destroyed. Calcrim 121, I've read this before, I want to repeat. Some testimony was given in Spanish. An interpreter has provided a translation for you at that time that the testimony was given. You, the jury, must rely on the translation provided, even if you understand the language spoken by the witness. Do not retranslate testimony for other jurors. If you believe the court interpreter translated testimony incorrectly, let me know by writing a written note. Calcrim 207. It is alleged that the crimes occurred on April 26th, 2023, April 29, 2023, and May 1st, 2023. The people are not required to prove the crimes took place exactly on those days, but only that they happened reasonably close to those days. Implicit bias, Calcrim 209. In your role as a juror, you must not let bias influence your assessment of the evidence or your decisions. I will now provide some information about how bias might affect decision making. Our brains help us navigate and respond quickly to events by grouping and categorizing people, places, and things. We all do this. These mental shortcuts are helpful in some situations, but in the courtroom, they may lead to biased decision making. Bias can affect what we notice and pay attention to, what we see and hear, what we remember, and how we perceive people, and how we make decisions. We may favor or be more likely to believe people whom we see as similar to us or with whom we identify. Conversely, we may disfavor or be less likely to believe people whom we see as different. Although we are aware of some of our biases, we may not be aware of all of them. We refer to those biases as implicit or unconscious. They may be based on stereotypes we would reject if someone brought that to our attention. Implicit or unconscious bias can affect how we perceive others and how we make decisions without our being aware of their effect. To ensure that bias does not affect your decisions in this case, consider these following steps. Reflect carefully and thoughtfully about the evidence. Think about why you are making each decision and examine it for bias. Resist the urge to jump to conclusions or to make judgments based on personal likes or dislikes. generalizations, prejudices, stereotypes, or biases. Consider your initial impressions of the people and the evidence in this case. Would your impression be different if any of the people were, for example, a different age, gender, race, religion, or otherwise? Was your opinion affected because that person has a disability or speaks in a language other than English or with an accent? Think about the people involved in this case as individuals. Focusing on individuals can help reduce the effect of stereotypes on decision making. Listen to the other jurors. Their backgrounds, experiences, and insights may be different from yours. Hearing and sharing different perspectives may help identify and eliminate biased conclusions. The law demands that jurors make unbiased decisions, and these strategies can help you fulfill that important responsibility. You must base your decisions solely on the evidence presented in this case, your evaluations of that evidence, your common sense and experience, and these legal instructions. Calcrim 220, the fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, brought to trial. A defendant in a criminal case is presumed to be innocent. The presumption requires that the people prove the defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proven their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. Calcrim Evidence 222. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Nothing that the attorneys say is evidence. In their opening statements, which we heard, and in a moment in closing arguments, the attorneys discussed this case. Their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorneys' questions are significant only if they helped you understand the witness answers. Do not assume something is true just because one of the attorneys asked a question that suggested it was true. During this trial, the attorneys may have objected to questions or moved to strike answers given by the witnesses. I ruled on the objections according to law. If I sustained an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. With respect to sustaining objections, one example is that you must ignore the questions asked by Prosecutor Vanderhook to the defendant about the absence of blood on his computer. The court sustained the objection to those repeated questions. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. During the trial, you were told that the people in the defense agreed or stipulated certain facts. This means that they both accept those facts as true. Because there is no dispute about those facts, you must accept them as true. As indicated, the court reporters made a record of everything that was said during the trial. If you decide that it is necessary, you may ask the court reporter's record be read back to you. You must accept the court reporter's record as accurate. Calcrim 223. Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the point to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it was raining outside. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction. And neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You, the jury, must decide whether a fact and issue has been proven based on the evidence. Calcrim 225, the people must prove not only that the defendant did the acts charged, but also that he acted with a particular intent or mental state. The instruction for each crime and allegation explains the intent or mental state required. An intent or mental state may be proven by circumstantial evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proven, you must be convinced that the people have proven each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to conclude that the defendant had the required intent or mental state, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant had the required intent or mental state. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the defendant did not have the required intent or mental state, and another reasonable conclusion supports a finding that the defendant did not, you must conclude that the required intent or mental state was not proven by circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject anything that is unreasonable. Calcrim 226, you alone must judge the credibility and believability of the witnesses. In deciding whether testimony is true and accurate, use common sense and experience. Judge the testimony of each witness by the same standards, setting aside any bias or prejudice. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much you believe. In evaluating a witness testimony, consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. And here's a list of factors. If you're having a discussion in jury deliberations and you're talking about a witness credibility, pull up 226, and these factors can be very helpful to your analysis. How well can the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember or describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is to be decided? What was the witness's attitude about the case and about testifying? Did the witness make a statement in the past that's consistent or inconsistent with his or her testimony? How reasonable is the testimony when considering all of the evidence? Did other evidence prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful? Has the witness been convicted of a felony? Has the witness engaged in other conduct that reflects on his or her believability? Was the witness promised immunity or leniency in exchange for testimony? Okay, there's a list. Now, do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you do not believe a witness testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statements on the subject. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things, told the truth about others, you may simply accept the part you think is true and ignore the rest. You, the jury, should use your common sense and experience in deciding whether testimony is true and accurate, as I've said. However, during your deliberations, do not make any statements or provide any information to other jurors based on any specialized training or unique personal experiences that you may have had related to the matters involved in this case. What you may know or have learned through your specialized training and specialized experience is not part of the evidence in this case and should not be relied upon. Calcrim 252. The crimes and other allegations in this case require the proof of the union or joint operation of an act and a wrongful intent. The following crimes require a specific intent or mental state. First-degree murder as alleged in counts 1 and 2. Second-degree murder as alleged in counts 1 and 2. And attempted murder as alleged in count 3. For you to find a person guilty of these crimes, that person must not only intentionally commit the act, the prohibited act, but must do so with a specific intent or mental state. The act and the specific intent or mental state required are explained in the instructions when I get to those specific charges. The following allegations require general criminal intent. Involuntary manslaughter as a lesser included offense to counts 1 and 2. Personal use of a deadly weapon as alleged in count enhancements 1A, 2A, and 3A. And personal infliction of great bodily injury as alleged in count enhancement 3B. For you to find these allegations true, that person must not only commit the prohibited act, but must do so with wrongful intent. A person acts with wrongful intent when he or she intentionally does a prohibited act. However, it's not required that he intend to break the law. The act required is explained in those instructions. We're going to get to that. All right, CalCrim 300. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. CalCrim 301. The testimony of only one witness can prove any fact. Before you conclude that the testimony of one witness proves a fact, you should carefully review all the evidence. CalCrim 302. If you determine there's a conflict in evidence, you must decide what evidence, if any, to believe. Do not simply count the number of witnesses who agree or disagree on a point and accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of prejudice or desire to favor one side or the other. What is important is whether the testimony or any other evidence convinces you, not just the number of witnesses who testify about a certain point. CalCrim 303, during the trial, certain evidence was admitted for a limited purpose. You may consider that evidence only for that purpose and no other. CalCrim 315 is eyewitness identification. You've heard eyewitness testimony identifying the defendant. As with other witnesses, you must decide whether an eyewitness gave truthful and accurate testimony. In evaluating identification testimony, consider these factors. Did the witness know or have contact with the defendant before the event? How well could the witness see the perpetrator? What were the circumstances affecting the witness's ability to observe, such as lighting, weather conditions, obstructions, distance, and duration of observation? How closely was the witness paying attention? Was the witness under stress when he or she made the observation? Did the witness give a description? And how does that description compare to the defendant? How much time passed between the event and the time that the witness identified the defendant? Was the witness asked to pick the perpetrator out of the group? Did the witness ever fail to identify the defendant? Did the witness ever change his or her mind about identification? Are the witness and the defendant different races? Were there any circumstances affecting the witness' ability to make an accurate identification? How certain was the witness when he or she made an identification? A witness's expression of certainty about identification, whether the identification was made before or at the trial, may not be a reliable indicator of accuracy. Among the factors you may consider when evaluating significance of the witness certainty in the identification are as follows. How soon after the event did the witness express certainty about the identification? If the witness made an identification before trial, did the witness express certainty at that time? Before the identification, did the witness express confidence in being able to make an identification? How confident was the witness in making this identification? Did the witness receive information before or after the identification that may have increased the witness's level of confidence? Did the police use procedures that increased the witness' level of confidence about the identification? The people have the burden of proving beyond a reasonable doubt that it was the defendant who committed this crime. If the people have not met this burden, you must find the defendant not guilty. So then, I want to stop for a second. Some of these instructions go on, right? So right now, you can't process every exact thing I'm saying. I just gave an instruction about dealing with identification, for example. I gave an instruction about witness credibility. So just know those are there. Listen generally right now. Process what you can, okay? But just pay attention to the nature and scope of these instructions so that you know, hey, I know where to go. I know what to look at when I'm in deliberations. I don't mean to overwhelm you. These are the legal instructions I have to give you, but it's not reasonable to think you're going to absorb every minute of this right now, okay? So don't put yourself under that burden. All right. Calcrim 316. If you find that a witness has been convicted of a felony, you may consider that fact in evaluating the credibility of the witness testimony. The fact of a conviction does not necessarily destroy or impair a witness credibility. It's up to you, the jury, to decide the weight of that fact and whether that fact makes the witness less believable. If you find a witness committed a crime or other misconduct, you may consider that fact only in evaluating the credibility of the witness's testimony. The fact that a witness may have committed a crime or other misconduct does not necessarily destroy or impair credibility. It's up to you, the jury, to decide what weight to give it and whether that fact makes the witness less believable. Calcrim 318. You have heard evidence of statements that a witness made before the trial. If you decide that the witness made those statements before the trial, you may use those pre-trial statements in two ways. One, to evaluate whether the witness testimony in court is believable, and two, as evidence that the information in those earlier statements is true. Deputy, could you pour me a glass of water? Thank you. Calcrim 332. Witnesses were allowed to testify as experts and to give opinions. You must consider the opinions, but you are not required to accept them as true or correct. The meaning and importance of any opinion are for you to decide. In evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, experience, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion, thank you, sir. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. An expert witness may be asked a hypothetical question. A hypothetical question asks the witness to assume certain facts are true and to give an opinion based on the assumed facts. It's up to you to decide whether an assumed fact has been proven. If you conclude that an assumed fact is not true, consider the effect of the expert's reliance on that fact in evaluating the expert's opinion. If the expert witnesses disagreed with one another, you should weigh each opinion against the others. You should examine the reasons given for each opinion and the facts or other matters on which each expert relied. You may also compare qualifications. Calcrim 333. Witnesses who were not testifying as experts gave their opinions during the trial. You may, but are not required to accept those opinions as true or correct. You may give the opinions whatever weight you think is appropriate. Consider the extent of the witness's opportunity to perceive the matters on which his or her opinion is based, the reasons the witness gave for any opinion, and the facts or information on which the witness relied in forming that opinion. You must decide whether information on which the witness relied is true and accurate. You may disregard all or any part of an opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Calcrim 358. You've heard evidence that the defendant made oral statements before the trial and or while the court was not in session. You must decide whether the defendant made those statements in whole or in parts. If you decide that the defendant made statements, consider the statements along with all the evidence in reaching your verdict. It's up to you to decide how much importance to give those statements. Consider with caution any statement made by the defendant intending to show his guilt unless the statement was written or otherwise recorded. Calcrim 359. The defendant may not be convicted of any crime based on his out-of-court statements alone. You may rely on the defendant's out-of-court statements to convict him only if you first conclude that other evidence shows that the charged crime was committed. The other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. This requirement of other evidence does not apply to proving the identity of the person who committed the crime and the degree of the crime. Other evidence shows that the charged crime was committed, the identity of the person who committed it, and the degree of the crime may be proved by the defendant's statements alone. You may not convict the defendant unless the people are proving guilt beyond a reasonable doubt. 362. If the defendant made a false or misleading statement before this trial relating to the charged crime, knowing the statement was false or intending to mislead, that conduct may show he was aware of his guilt of the crime, and you may consider it in determining guilt. If you conclude that the defendant made the statement, it's up to you to decide its meaning and importance. However, evidence that the defendant made such a statement cannot prove guilt by itself. Motive. Calcrim 370. The people are not required to prove the defendant had a motive to commit any of the crimes charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Having a motive may be a factor tending to show that the defendant is guilty. Not having a motive may be a factor tending to show the defendant is not guilty. Calcrim 371. If the defendant tried to hide evidence, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such an attempt, it's up to you to decide the meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. Calcrim 372. If the defendant fled immediately after the crime was committed, that conduct may show that he was aware of guilt. If you conclude that the defendant fled, it's up to you to decide the meaning and importance of that conduct. However, evidence that the defendant fled cannot prove guilt by itself. All right, now we move on. Those are the general instructions, okay? And so you got to make sure you know where to go, all right? So now I'm going to get into the actual instructions to the charged offenses. Calcrim 500. Homicide is the killing of one human being by another. Murder and manslaughter are types of homicide. The defendant is charged with murder. Manslaughter is a lesser offense to murder. Calcrim 520. The defendant is charged in counts 1 and 2 with murder in violation of Penal Code Section 187. To prove that the defendant is guilty of this crime, the people must prove the following. First, the defendant committed an act that caused the death of another person. And second, when the defendant acted, he had a state of mind called malice aforethought. There are two kinds of malice aforethought: express malice and implied malice. Proof of either is sufficient to establish the state of mind required for murder. The defendant had express malice if he unlawfully intended to kill. The defendant had implied malice if, 1, he intentionally committed the act, 2, the natural and probable consequences of the act were dangerous to human life, in that the act involved a high degree of probability that it would result in death. 3, at the time he acted, he knew his act was dangerous to human life. And 4, he deliberately acted with conscious disregard for human life. Malice aforethought does not require hatred or ill will toward the victim. It is a mental state that must be formed before the act that causes death, the death is committed. It does not require deliberation or the passage of any particular period of time. An act causes death if the death is direct, natural, and probable consequence of the act, and the death would not have happened without the act. A natural and probable consequence is one that a reasonable person would know is likely to happen if nothing unusual intervenes. In deciding whether a consequence is natural and probable, consider all the circumstances established by the evidence. If you decide that the defendant committed murder, it is murder of the second degree, unless the people have proved beyond a reasonable doubt that it is murder of the first degree, as defined by Calcrim 512. Do I have that instruction, counsel? 512?
512. So as well.
Do you have a hard copy of that? Or maybe that's a typo. That's why it threw me. That's a typo. It's not 512, it's 521.
Yes.
And I do, of course I have 521. I'm going to read that next. All right? There's a typo there. Fixed. 521. The defendant is guilty of first-degree murder if the people have proven that he acted willfully, deliberately, and with premeditation. The defendant acted willfully if he intended to kill. The defendant acted deliberately if he carefully weighed the considerations for and against his choice, and knowing the consequences, decided to kill. The defendant acted with premeditation if he decided to kill before completing the act that caused the death. The length of time the person spends considering whether to kill does not alone determine whether the killing is deliberate and premeditated. The amount of time required for deliberation and premeditation may vary from person to person and according to the circumstances. A decision to kill may be made rashly, impulsively, or without careful consideration. A decision to kill made rashly, impulsively, or without careful consideration is not deliberate and premeditated. On the other hand, a cold, calculated decision to kill can be reached quickly. The test is the extent of the reflection, not the length of time. Karim 580. When a person commits an unlawful killing, but does not intend to kill, does not act with conscious disregard for human life, then the crime is involuntary manslaughter. The difference between other homicide offenses and involuntary manslaughter depends on whether the person was aware of the risk to life that his actions created and consciously disregarded that risk. An unlawful killing caused by a willful act done with full knowledge and awareness that the person is endangering the life of another and done in conscious disregard of that risk is murder in this case, or voluntary manslaughter, which is not an issue. An unlawful killing resulted from a willful act committed without intent to kill and without conscious disregard of the risk to human life is involuntary manslaughter. The defendant committed involuntary manslaughter if 1. The defendant committed a crime. 2. The defendant committed the crime with criminal negligence. And 3. The defendant's acts caused the death of another person. The people allege that the defendant committed the following crime: assault. Instruction 915 tells you what the people must prove in order to prove that the defendant committed an assault. Criminal negligence involves more than ordinary carelessness, inattention, or mistake in judgment. A person acts with criminal negligence when 1. He acts in a reckless way that creates a high risk of death or great bodily injury, and 2. A reasonable person would have known that acting in that way would create such a risk. In other words, a person acts with criminal negligence when the way he acts is so different from the way an ordinary, careful person would act in the same situation that his act amounts to disregard for human life or indifference to the consequences of that act. Great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. In order to prove murder, the people have the burden to prove beyond a reasonable doubt that the defendant acted with the intent to kill or with a conscious disregard for human life. If the people have not met either of these burdens, you must find the defendant not guilty of murder. Karim 600. The defendant is charged in count 3 with attempted murder. To prove that the defendant is guilty of attempted murder, the people must prove 1. The defendant took at least one direct but ineffective step toward killing another person, and 2. The defendant intended to kill that person. A direct step requires more than merely planning or preparing to commit murder, or obtaining or arranging for something needed to commit murder. A direct step is one that goes beyond planning or preparation and shows that a person is putting his or her plan into action. A direct step indicates a definite and unambiguous intent to kill. It is direct movement toward the commission of the crime after preparations are made. It is an immediate step that puts the plan in motion so that the plan would have been completed if some circumstance outside the plan had not interrupted the attempt. If you find that...
All right, so that's the one they had a question about, was 600, the direct step. So that was the one that they had the question about. And the direct step, what goes beyond the plan, and Judge said he'll refer them back to that instruction, the direct step. Then he said something, Judge said, thrusting a knife into the backside of Kimberlee needs specific intent to delete, and we gave them the instruction. So he says it's frustrating, but it's an accurate statement of the law, and he was comfortable with that. So that was their question was on that.
The defendant guilty of attempted murder, you must then decide whether the people have proven the additional allegation that the attempted murder was done willfully and with deliberation and premeditation. The defendant acted willfully if he intended to kill when he acted. The defendant deliberated if he carefully weighed the consideration for and against his choice, and knowing the consequences, decided to kill. The defendant acted with premeditation if he decided to kill before completing the act of attempted murder. The defendant acted with premeditation if he decided to kill before completing, well, I just repeated that, the act of attempted murder. The length of time the person spends considering whether to kill does not alone determine whether the attempted killing is deliberate and premeditated. The amount of time required for deliberation and premeditation may vary from person to person and according to the circumstances. A decision to kill made rashly, impulsively, or without careful consideration of the choice and its consequences is not deliberate and not premeditated. On the other hand, a cold, calculated decision to kill can be reached quickly. The test is the extent of the reflection, not the length of time. The people have the burden to prove this allegation beyond a reasonable doubt. If the people have not met this burden, you must find this allegation has not been proven. Just a moment. Calcrim 3428. You have heard evidence that the defendant may have suffered from a mental disease, defect, or disorder. You may consider this evidence for the limited purpose, only for the limited purpose of 1, deciding whether, at the time of the charged crime, the defendant acted with the intent or mental state required for that crime. 2, deciding whether, if the defendant made a false statement, the defendant made that statement knowing the statement was false. 3, assessing and evaluating the defendant's ability to perceive, recall, or describe the events in question. In counts 1 and 2, the people have the burden of proving beyond a reasonable doubt that the defendant acted with the required intent or mental state, specifically whether the defendant acted with malice aforethought. If people have not met this burden, you must find the defendant not guilty of murder. You must consider each count separately and return a separate verdict for each one. If you find the defendant guilty of murder in count 1 or 2, the people have the burden of proving beyond a reasonable doubt that the defendant acted with the required intent or mental state for first-degree murder, specifically whether the defendant acted willfully and with deliberation and premeditation. If the people have not met this burden, you must find that any murder is a murder in the second degree. You must consider each count separately and return a separate verdict for each one. The people have the burden to prove beyond a reasonable doubt that the defendant acted with the required intent or mental state, whether the defendant intended to kill Kimberlee Guillory. If the people have not met this burden, you must find the defendant not guilty of attempted murder. If you find the defendant guilty of attempted murder in count 3, the people have the burden to prove beyond a reasonable doubt that the defendant acted with the required intent or mental state for first-degree murder, whether the defendant acted willfully and with deliberation and premeditation. If the people have not met the burden, you must find the allegations that the attempted murder of Kimberlee Guillory was willful, premeditated, and deliberate is not true. Calcrim 331. In evaluating the testimony of a person with a mental impairment, consider all the factors surrounding that person's testimony, including his or her level of cognitive development. Even though a person with a mental impairment may perform differently as a witness because of his or her level of cognitive development, that does not mean he is any more or less credible than other witnesses. You should not discount or distrust the testimony of a person with a mental impairment solely because he has such an impairment. Calcrim 627, a hallucination is a perception not based on objective reality. In other words, a person has a hallucination when that person believes he or she is seeing or otherwise perceiving something that is not actually present or happening. You may consider evidence of hallucinations, if any, in deciding whether the defendant acted with deliberation and premeditation and as to any specific intent or mental state concerning any of the charged crimes in this case. The people have the burden of proving beyond a reasonable doubt that the defendant acted with deliberation and premeditation and other specific intent as set forth here and other mental state. If the people have not met this burden, you must find the defendant not guilty of first-degree murder. All right, this is Calcrim 640. I'm not supposed to emphasize instructions, but this one is complex. It's like a recipe for how you work through handling first-degree murder, second-degree murder, and voluntary manslaughter, okay? I'm only identifying that it's a 2-page instruction, and you'll need to go through it particularly when you get the verdict form. This is Calcrim 640. For each count charging murder, you will be given verdict forms for guilty and not guilty of first-degree murder, second-degree murder, and involuntary manslaughter. It is up to you to decide the order in which you consider these different kinds of homicide and the relevant evidence. For example, you do not have to reach a verdict on the first-degree murder charges before considering second-degree murder charges or involuntary manslaughter charges. However, I can accept a verdict of guilty or not guilty of second-degree murder only if all of you have found the defendant not guilty of first-degree murder. And I can accept a verdict of guilty or not guilty of involuntary manslaughter only if all of you have found the defendant not guilty of both first and second-degree murder. As with all the charges in this case, to return a verdict of guilty or not guilty on a count, you must all agree on that decision. Follow these instructions before you give me any signed, completed verdict forms. Return the unused verdict form to me unsigned. All right, so this is a 7-step recipe for anyone here that's a good cook. All right, number 1, if all of you agree that the people have proved beyond a reasonable doubt that the defendant is guilty of first-degree murder, complete and sign the verdict form. Do not complete or sign any other verdict forms for that count. 2, if all of you cannot agree whether the defendant is guilty of first-degree murder, inform me in a written note that you cannot reach an agreement and do not complete or sign any verdict forms for that count. 3, if all of you agree that the defendant is not guilty of first-degree murder, but also agree that the defendant is guilty of second-degree murder, complete and sign the form for not guilty for first-degree murder and the form for guilty for second-degree murder. Do not complete or sign any other verdict forms for that count. 4, if all of you agree that the defendant is not guilty of first-degree murder, but cannot agree whether the defendant is guilty of second-degree murder, complete and sign the form for not guilty of first-degree murder and inform me in a written note that you cannot reach further agreement. Do not complete or sign any other verdict forms for that count. 5, if all of you agree that the defendant is not guilty of first-degree murder and not guilty of second-degree murder, but also agree that the defendant is guilty of involuntary manslaughter, complete and sign the forms for not guilty of first-degree murder, not guilty of second-degree murder, and the form for guilty for involuntary manslaughter. Do not complete or sign any other verdict forms for that count. 6, if all of you agree that the defendant is not guilty of first-degree murder and not guilty of second-degree murder, but cannot agree whether the defendant is guilty of involuntary manslaughter, complete and sign the forms for not guilty of first-degree murder and not guilty of second-degree murder, and inform me that you cannot reach further agreement. Do not complete or sign any other verdict forms for that count. And finally, 7, if all of you agree that the defendant is not guilty of first-degree murder, not guilty of second-degree murder, and not guilty of involuntary manslaughter, complete and sign the verdict forms for not guilty of each crime. Do not complete any other forms for that count. All right, I'm almost done here. Bear with me. Calcrim 700. If you find the defendant guilty of first-degree murder, you must also decide whether the people have proven that the special circumstance is true. The people have the burden of proving special circumstance beyond a reasonable doubt. If the people have not met this burden, you must find the special circumstance has not been proven. In order for you to return a finding that a special circumstance is or is not true, all 12 of you must agree. Here's the special circumstance at issue in this case. Calcrim 721. The defendant is charged with the special circumstance of having been convicted of more than one murder in this case in violation of Penal Code Section 190.2, subdivision A3. To prove that this special circumstance is true, The people must prove, 1, the defendant has been convicted of at least one charge of first-degree murder in this case, and secondly, the defendant has been convicted of at least one additional charge of either first or second-degree murder in the case. All right, and then we referenced simple assault earlier. This is Calcrim 915. To prove the defendant committed the crime of assault, 1, the defendant did an act that by its nature would directly and probably result in the application of force to that person. 2, the defendant did that act willfully. 3, when the defendant acted, he was aware of facts that would lead a reasonable person to realize that his act by its nature would directly and probably result in the application of force to someone. And 4, when the defendant acted, he had the present ability to apply force to a person. Someone commits an act willfully when he or she does it willingly or on purpose. It's not required that he or she intend to break the law, hurt someone else, or gain an advantage. The terms application of force and apply force mean to touch in a harmful or offensive manner. The slightest touching can be enough if it is done in a rude or angry way. Making contact with another person, including through his or her clothing, is enough. The touching does not have to cause pain or injury of any kind. The touching can be done indirectly or by causing an object to touch the other person. The people are not required to prove that the defendant actually intended to use force against someone when he acted. No one needs to actually have been injured by the defendant's acts, but if someone's injured, you may consider that fact along with the other evidence in deciding whether the defendant committed an assault. Voluntary intoxication is not a defense to assault. All right. Great bodily injury. Calcrim 3160. If you find the defendant guilty of the crime charged in count 3, you must decide whether the people have proven the additional allegation that the defendant personally inflicted great bodily injury on Kimberlee Guillory during the commission of that crime. Great bodily injury means significant or substantial physical injury. It's an injury that is greater than minor or moderate harm. Just 2 or 3 more, folks. Thank you. Just a moment. If you find the defendant guilty of the crimes charged, this is Calcrim 3145, of the crimes charged in counts 1, 2, or 3, or any lesser included offenses, you must then decide whether for each crime the people have proven the additional allegation that the defendant personally used a deadly weapon during the commission of that crime. You must decide whether the people have proven this allegation for each crime and return a separate finding for each crime. A deadly weapon is any object, instrument, or weapon that is inherently deadly, or one that is used in such a way that is capable of causing and likely to cause death or great bodily injury. An object is inherently deadly if it is deadly or dangerous in the ordinary course for which it was designed. In deciding whether an object is a deadly weapon, consider all the surrounding circumstances, including when and where the object was possessed, where the person who possessed the object was going, and any other evidence that indicates whether the object would be used for a dangerous rather than a harmless purpose. Great bodily injury means significant or substantial physical injury. It's an injury that is greater than minor or moderate. Someone personally uses a deadly weapon if he or she intentionally does the following: hits someone with a weapon, cuts someone with a weapon, or stabs someone with a weapon. The people have the burden of proving each allegation beyond a reasonable doubt. The people have met this burden. You must find the allegation, if the people have not met the burden, you must find the allegation not proved. Calcrim 3515, each of the counts charged in the case is separate. You must consider each count separately and return a separate verdict form for each. In additional instruction, the question whether law enforcement officers were required to advise the defendant of his Miranda rights before questioning him at the scene of his detention is a question of law and is not an issue to be decided by this jury. You may, however, consider the conduct of law enforcement officers in assessing their credibility and the effect as to the issues to be decided in this case. Another special instruction, the court may take judicial notice, or I am taking judicial notice of the following facts. In April and May of 2023, the state of California was utilizing Pacific Daylight Time, or PDT. Coordinated Universal Time is 7 hours ahead of PDT. Sunset on April 29th in the city of Davis was at 7:56. And my final instruction to you at this time, and I'll have additional short instructions after closing arguments. The defendant has entered pleas of not guilty and not guilty by reason of insanity. The procedure for this case is to try the question of guilt first, and then, if necessary, to try the question of insanity separately. These are two distinct phases. We are in the first phase of this trial only at this time. You, the jury, shall not consider the question.
All right, I want to play that again because he was very, very clear about the two phases. So I'm going to play that again.
California was utilizing Pacific Daylight Time, or PDT. Coordinated Universal Time is 7 hours ahead of PDT. Sunset on April 29th in the city of Davis was at 7:56. And my final instruction to you at this time, and I'll have additional short instructions after closing arguments. The defendant has entered pleas of not guilty and not guilty by reason of insanity. The procedure for this case is to try the question of guilt first, and then, if necessary, to try the question of insanity separately. These are two.
So as we've been talking this whole time, so guilt first and then insanity. And yet they brought in so much expert witness on that he had schizophrenia. So how can that not be weighing on the juror's mind? I just don't understand that. Because how can you say, well, he's not guilty because he had schizophrenia, or he's guilty? I don't know. This trial is really, really confusing. All right, I'm going to play it one more time.
Distinct question. The defendant has entered pleas of not guilty and not guilty by reason of insanity. The procedure for this case is to try the question of guilt first, and then, if necessary, to try the question of insanity separately. These are two distinct phases. We are in the first phase of this trial only at this time. You, the jury, shall not consider the question of legal insanity in the first phase. You may consider, and I've given instructions on this, evidence of the defendant's state of mind in this phase of the trial. You also shall not consider any time or anything, shall not consider during deliberations anything that was said on the jury questionnaire or during voir dire.
Yeah, those are two really good things. Psychosaurus says the experts did not opine on sanity. They only discussed their clinical opinion of diagnosis. But yeah, for the jurors, that's a nuance they may not realize or think about. And I kind of think that's what happened with Megan Boswell. You know, I think she got a raw deal. I think they said, oh, she's guilty. But I think she needs some serious help. And then Baca, the defense, said in his opening, Carlos is guilty. That is absolutely true, and is very, in my notes, like he literally said, let me go back to my notes. Not disputing the actions. This was the defense. This was Mr. Hutchinson's opening. Not disputing the actions. The question is, what was Carlos's specific intent and mental state? Evidence will show he has schizophrenia. Every professional has reached the same decision and not malingering, which is faking or exaggerating. So they're not disputing the actions. Question is, what was Carlos's specific intent and mental state? So I don't know. For an insanity plea, you have to admit guilt. All right. Jurors weren't listening or comprehending. It's a lot. I mean, I was starting to glaze over too. I mean, it's a lot. I would have, I don't know. It's a lot. All right, let me keep playing it, see where we go.
Jury selection serves a different purpose. Okay. All right, those are my instructions. All right, I was hoping to do those in about 35 minutes, and I read steadily and did 55 minutes. I'm sorry. So let's go ahead and stand up and stretch those.
All right, so that's pretty much it for that. Let's go back to kitties. Unless you guys want to watch something else, if you guys want me to pull up another pull up another section we can rewatch while we're waiting. Irish Amy says, maybe they do understand the different phases but are stuck on which guilty. Yeah, they've got, here are their, well, we took a poll a while ago and we were pretty much like 30%. Hold on, let me see if I can find that. So they have to, guilty, first degree would be they were premeditated, right? So they either just straight up, this was premeditated, I don't care what you say, premeditated, boom. Second degree would be they were planned. Oh no, they were not planned. But they were still intentional. And then manslaughter is no intent or malice. So Hutchinson is asking for involuntary manslaughter. So he's saying, okay, if you find him guilty, find him on involuntary manslaughter. That's where Hutchinson is going. Abe says, yeah, it's an affirmative defense like self-defense would be. You admit to the act, but not that it's criminal. Right? To which Psychosaurus says yes. Psychosaurus, if you're trying to say you're not guilty of reason of insanity, you cannot say you didn't do the offense, right? Let's see. Ooh, lightning. Dr. X, do you think the lay jury is confused with the two-step process? Did you guys hear that? Having a lightning storm right now. I've been thinking of insanity a lot over the weekend while reading a lot of alienist reports on patients, and I think I need to rewatch the 6-hour interview of Carlos because I have some thoughts. Yes, kitties are definitely getting bigger. I don't necessarily see a runt yet. Oh, look at that little ginger. Oh, wow. That was right in front of me. You know when you hear the crackle? Here, listen. Yeah. That was close. That one was close. I could hear the crackle. I could hear the sizzle. You know it's close when you hear the sizzle. Gulp. We got ourselves a storm. Storms are coming. Let me check our radar. Oh, excuse me. Yep. We're about to get smacked. It's coming right at us. Irish Amy, would love to hear your thoughts if you wanted to share after you've done that. Do you hear it? Do you hear it? I can't tell if you guys can hear it or not. Abe says they all look really healthy. Yeah, they do. JWD, oh, there's a calico kitty there. That's definitely a female. Any lawyers here? Could they have done not guilty reason insanity trial deliberations in a second phase, or is it 2 phases legally required here? I do not know, just Shamrock. You guys hear it? Okay. You hear it for sure? You can hear it? All right. Thunder is scary. Nope. I'll share if I can get around to watching it and fully focusing on it. Ruby's hearing it too. Abe says, yeah, it feels like they're splitting hairs with the 2-step process. Your husband heard it from the kitchen. Yeah. Watch your computers. Lightning and computers don't go well together. I know. I'm keeping a sharp eye. It's coming right at me. I'm just looking out the window. It's coming right at us. It's pretty dark out. Well, it's getting darker. We'll stay on as long as we can. Hopefully I won't get zapped. Let's see. JWD says 2 males, 2 females. Oh, boop, 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 boop. Heavy rain starting in 20 minutes. Drunky the Bear. Looks like Trial TV Live is pranking us by switching tiny kittens for gigantic ones. I know. Poor Paulie. Off topic. Do we have a new trial on the horizon? There's one starting tomorrow out of Connecticut that looks like it might be interesting. Well, we're pretty much locked into this one. I want to, now that we went through phase 1, I want to go through phase 2. We have Stefan Stearns coming up in July. We have Donna Adelson coming up in August. So, but thank you for that, Golden Girl. There's always a new trial, right? I don't want to abandon Carlos. We've put too much time into Carlos, and I want to see it through for the second phase. He said a 10-week trial, and first phase. How long was his first phase? I did not write down when it started. I have to start doing that so I could see how long. But yeah, I can't believe I didn't write down when it started. You want Lori to get zapped, not me? Yeah. No zapping, please. Best sound in the world. It's. I don't mind thunderstorms. I like thunderstorms. Golden Girl, yeah, I get it. I forgot we have phase 2. If we didn't have phase 2, if we were just looking for a guilty, not guilty and call it a day, yeah, we'd be going on to that Megan Jackson. We'd be going on to the one in Connecticut. Yeah, there's plenty of other trials to catch up on or watch. But because we have the second phase, I want to see it through. So he said it was going to be a 10-week trial. We're into day 27, so you have to figure that's at least 4 weeks. So the second one is going to be, we got Stefan Stearns July 14th. I'm definitely going to cover him. So I hope this is done by then. We may be in verdict watch by then, but I'm not going to lose Stefan Stearns. May 5th was openings. Oh, thank you. Cool, thank you. I'm going to jot that down. Thank you, therapist. So May 5th. Okay, May 5th. Thank you for that. So, appreciate that. Joe Shamrock, I'm going on vacation next week, so they've got to wrap it up this week. Psychosaurus Rex, I definitely want to hear phase 2. I want to hear their opinions, only experts on sanity. Give my own current thoughts on the matter. Abe says, definitely have concerns. I think was the face-eating Uber driver that came to mind. Like he didn't know he was psychotic, but he definitely was. He pled guilty. Let's see, another question off topic, Lily Wayne. Has the man who unalived his 3 daughters got caught? I don't know. I'm not quite sure. Not caught yet. Baca says, won't phase 2 simply be a repeat of phase 1? Probably, yeah. Who else are they going to bring in? They're going to bring in their experts. Not caught yet. Penny says, just checking in. Is there a verdict yet? There is not. Psychosaurus says, hearing that storm in my ear, I started thinking it was storming here. Then I looked out my window. It was like, oh, right, blue skies and sun. It's definitely getting darker. It's getting darker for us. No verdict yet. Travis Decker has not been caught yet. Sheriff just updated the press today. Blue skies here in West Texas, along with the stupid wind, says therapist. Oh, let me play some music. Oh, there comes another one. Get ready. Here comes another one. Another thunder coming in. That was another one. So Florida is the lightning capital of the world, or at least of the U.S. I'm pretty sure it's the lightning capital of the world. Let me see. Lightning capital of the world. Oh, Venezuela is widely considered the lightning capital of the world according to NASA. Lake Maracaibo. However, the lightning capital of the U.S. is in Florida. All right. I thought Florida was the lightning capital. Is Florida the lightning capital of the U.S.? Yes. Known as the lightning capital of the United States, experiences more lightning strikes per square mile than any other state. With an average of 1.2 million strikes annually, Florida's frequent thunderstorms pose serious risks to people, pets, and property. And then they're considering Tampa is often considered the lightning capital of the United States due to its high frequency of thunderstorm activity and lightning strikes. So there you go. So Florida's the lightning capital of the country, and Florida is the Florida is the lightning capital of the country. Tampa is the lightning capital of Florida. So, ergo, Tampa is the lightning capital of the United States. But Lake Maracaibo in Venezuela, specifically where the Catatumbo River flows into it, lightning occurs almost every night, up to 3,000 nights a year. It's known as Catatumbo lightning storm. All right. I did not know that. Oh, you're terrified of thunder, JWD? Yeah. It can be frightening. It can be scary. I just imagine what people did. I don't know, 500 years ago, 1,000 years ago, 5,000 years ago. What were they thinking when they, when a storm? 10,000 years ago, what were they thinking? Just Shamrock, I love storms and thunder, but the lightning causes too many wildfires where you are. That's true. Oh, you got to be careful for that. Psychosaurus says, that's wild, and I thought Michigan had bad storms. Thunderstorms and lightning are so scary, and if we get lightning here, the whole state goes up in flames. Yeah, that's Just Shamrock. I think you guys are in the same state. Irish Amy says, I love storms too, but that might be because where I am, they are rarely dangerous. Oh, look at Paulie flopping over. Paulie's so cute. I wanted to go in there. I went in there, but the camera wasn't working. I went in there and I was petting them, and I looked over and the camera wasn't working. Damn it. Baca says, you bought your 4-year-old granddaughter a silly book about thunder. She's afraid. Might be another one. I just saw some light. I saw some lightning. There it goes. Wow. I don't know if you can hear the house. The house shakes. JWD, when I was a kid, my best friend got struck when we were standing near an electricity plant. Oh my gosh, and she passed away? Wow. I'm so sorry, JWD. Good Lord. Dennis says, I will enjoy my earthquakes versus Florida storms. Right? Did you see it? Did you see the flash? Wow. Yeah, JWD, that's pretty intense. That's pretty intense. When I was working, I was a lifeguard. I was working at this one lake, and electric worker guy working on the electricity or whatever. Excuse me. He was working not lightning, but just straight up electricity, and he zapped himself. I didn't see it, but we heard about it. So that's as close as I've been to. I don't mess with electricity. I hire somebody. I'm like, yep, nope, not going to mess with that stuff. I guess as long as you're in a safe place, it's not too bad. Yeah, I can't even imagine JWD's witnessing something like that as a kid. That would cause some trauma for me, for sure. Play some music, why not, right? Just play some music there. I remember as a kid, I still do, I loved scary movies, right? And Alfred Hitchcock, loved Alfred Hitchcock growing up. And there was this one movie, I forget when it was on. Maybe it was on at night, I forget. But I was small. I was like 5 or 6. And it was like this woman was in a mansion, right? And there's lightning flashing, huge lightning storm, and she hears this knock. Right? She just keeps hearing this knock, 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 knock. So, of course, the power's out. She gets the candles, the candelabra, and she goes down. And of course, she's wearing probably this white flowing robe or whatever, outfit. And she goes down, and no lights, right? So she just has this candle, and you know there's going to be a jump scare at some point. And she opens, or the curtain, I guess, was open, and it's all dark outside, and all of a sudden this huge lightning strike happens and lights up the entire, whatever front lawn, and there's a tree, and of course there's this guy hanging, swinging, knocking against the tree. And I've been traumatized since then about thunderstorms, but I do like a good thunderstorm. Irish Amy, yes, Hitchcock is awesome. He's fantastic. I love a good candelabra. Psychosaurus Rex. You ran to your neighbors for help, JW? Aw. You thought she was just messing around because she used to joke about things like that. So I didn't think it was real, but when she was down and kicked her slightly, I can't even imagine. Can't even imagine. Oof. I love white flowing robes and candlelight. Yeah, it was like a classic, horror. And I just remember that one little section. I don't remember what the whole movie was about. It could have been like just a little clip. Could have been. I don't remember it, but it definitely has stuck with me to this day. Hey, we get evening thunderstorms here during the summer. I love them. Here comes the rain. I don't know if you can hear the rain or not. Yeah, there's nothing more cool than like seeing like if you're at the ocean or a lake or whatever, and you can look out and you see a thunderstorm like 10 miles away. I love that. That's pretty cool. The storm is not phasing the cats. That is true. They are not responding. Abe, I'll never forgive Edison for destroying the candelabra industry. Nice. Heat lightning you don't mind, mostly stays in the clouds. Ground strikes, nope. That is true. Yeah, heat lightning, I think, that's just cloud to cloud. I don't think that ever goes down. You can hear the rain, Ruby? Here, let me turn this off. I'll turn that down. It's not too hard right now, not too much. When I was a kid, I used to go out and record the wind through the trees. We had these pine trees, so I'd go and I'd record the wind, and then of course rain. I love just the sound of rain. Yeah, it's not too hard. There's some more thunder. JWD, I try to overcome my fear, but it's so hard to overcome something like that. Yeah, don't even try. Just absorb it and accept it. It's really not much you can do to overcome it. All right, nothing from Newton yet. 5:30. It's at 2:30 over there. JWD, thunderstorms, I just run, going, oh, no, run into the bed. My mom didn't like thunderstorms either. She was not a fan of thunderstorms. All right, I guess you guys might be able to hear the rain now. It's starting to get a little bit heavier. We had this is now typical Florida summer pattern, right? Really beautiful all day, hot and humid. We were about 88, 89, humid, and then it builds up for the afternoon, and then it rains rains about this time. So we did this Saturday, we did this Sunday. I don't remember if we did it Friday, but here we are Monday. So just Abe says, I played outside during thunderstorms. I love the wind. Yeah, there's nothing better than a nice walk in the wind, when it's like when a front comes through or before. And Abe, I love right before a thunderstorm, because you can just feel it. You can just feel the electricity, and everything is just still and it's just ready to explode. It's like it's sucking itself in only to explode. So, yeah, I really like thunderstorms, like right before them too. And then the wind. Yeah, I used to love walking in the woods with wind, on a windy day. Psychosaurus Rex, I really can't believe this verdict is taking so long. Phases and mental health stuff aside, this is wild. JWD, wouldn't it be so nice if we could build a home that protects us from all trauma, tornadoes, hurricanes, thunderstorms, floods, fires? It's there's always going to be something, you guys. It's always going to be something. A similar pattern to here. Hot days, then a rain in the later afternoon. You can feel the moisture and smell it coming. Yeah, I smell the ground. I smell dirt. Whenever we're outside and you catch the wind, you can smell the dirt. Yeah, Irish Amy says, Abe, same. I always go out in torrential rain. Abe says, yeah, summer thunderstorms are my favorite weather. Sunny is too hot for you. And then in Florida, there's an adage: if you don't like the weather, just wait 5 minutes because it'll change. Because then it'll be sunny. I don't think today it'll be sunny after. Well, who knows? It may. But they're kind of bubbling up all over. But that happens a lot. Where if you don't like the weather, just wait 5 minutes because it will change. There, Shirley says, yeah, JWD. They're called bunkers. I guess so. I guess you're right about that. All right, Newton, are you with us? Are you still with us? Let me see if Newton's still with us. See if Newton is still with us. More importantly, yes, is the jury still with us? Irish Amy says she can't resist a good rain dance. Paging Newton Ward. Irish says, Irish Amy, I love the heat, but always have time for water and storms. Ooh. Reconnect. So this heavy rain isn't turning out to be such a heavy rain after all. Irish Amy asks, is the jury still with us? Period would be my question. They haven't been lost in a portal. Missy says, I want to cuddle with Polly. She looks so sweet. Yes, Irish Amy, she is. According to the instructions, they can consider him innocent after all. I don't think so. I don't think so, because they have to do first degree, second degree, or involuntary manslaughter. No, I don't think there's a not guilty. I don't. Those were the three charges. First degree, second degree, and then involuntary. Involuntary manslaughter. So, I don't think, no, because as Psychosaurus Rex was saying, if you say not guilty reason of insanity, you have to admit, you are admitting that you did it. So I don't I don't think there's a innocent selection. Oh, here, let me open this up a little bit more, see if we can get more of Polly in here. Can I do that? I guess I can't. She's at the edge of the, yeah. I was going to open it up so we could see her face a little bit more, but. All right, 5:30 here on the East Coast, 2:30 over there. Baca, didn't it? All the mental illness should have come into. Don't you think it did? I feel like we heard from four doctors and then 2 healthcare professionals. I felt like we did. Oh, should not have. Okay, should not have. Yeah. Right? It's a confusing trial. There's no question about it. I just want the kid to get some help. However, whatever that's going to be, just get this kid some help. All right. Yep. Never shame you the same. Bacchus has too confusing for the jurors. Unless somebody's digging their heels in and they're like, nope, I don't care about his mental, whatever you want to call it. This was intentional. I'm not changing. And there could be 2 or 3 because we were pretty much split. We had, out of 85 votes, we had first degree, which was premeditated, 37%. Second degree, which was not planned, was 32%. And involuntary manslaughter, no intent or malice, was 29%. So pretty much we were, 30. So there could be, out of 12 people, there could be 3 of them that are saying, or 4 of them, no, manslaughter. This kid didn't know what he was doing. And then there could be 4 or 5 saying, no, first degree. He premeditated this. He went out. He left his cell phone at home. He had a knife with him. And then there could be 2 or 3 that are saying, well, I don't think it was planned, but it's still intentional. This is so messy. This is a messy, messy trial. Messy trial. Yeah, I don't know if, well, I can see all 3 sides to it. Yeah, I agree, Abe. There's a lot of nuance to this case. It's not like Stefan Stearns where we're like, or Lori Daybell, we're like, yeah, no. They are guilty. They were obvious villains. Carlos is a villain, but there's a big but. There's a but in there. It's like, yeah, he did it. He's a villain, but he had a raw deal growing up and a raw deal now. Lori, who knows what kind of deal she had. Stefan, who knows what, He's not claiming he was insane. You know what I'm saying? So I think Carlos just had a raw deal. Not that makes it better justified what he did, but there's a big but in there. You can't just say he's just a straight up villain, Some of you are saying that, I get it, but I would say no. Brett says, when you were growing up in Albuquerque, monsoon season, we sometimes lost power with the storms. Then we played Scrabble by candlelight. No, that's cool. That sounds like fun. Oh, really? Did somebody get botted on the word hung? I don't see that somebody got botted for that. Yeah, Abe, no one chooses schizophrenia. Yeah, it's a big complication. I totally agree. Yep, sign me up. Sign me up for that. Yeah, no way. Irish Amy, that isn't weird. Sounds awesome. We did similar, but with cards. Yeah, we would play a lot of cards. Zach, I came back to Chris talking about big butts. And I cannot lie. Yes, that's a big butt. That's a big butt, Zach. Big butt. Yeah, we played cards a lot. We played a lot of cards growing up. We had lots of, we played Monopoly, Scrabble. What else did we have? We had a ton of games. I'm trying to think of all. Sorry. Oh, excuse me. I'm trying to think of all of them. I'm drawing a blank on the games I used to play. Life. I think we had Life. Cards was just big. Yeah, cards. I played a lot of cards. Oh, Baca, no bot. Chat didn't appear on TV though. Secosaurus says you gladly play Scrabble out by candlelight, even with power. JWD, if it was me, I couldn't be fair for the verdict either. I would give the hardest penalty or be too easy on my verdict. Now, so I could understand how the jury might be feeling. So you're either black or white on this one, which would be first degree, throw the book at him, or involuntary, which would be kid needs help, I guess. Even if he is first degree, I wonder. Okay, maybe this will help me figure it out. Psychosaurus, can you answer this question? Oh, Zach, gonna hide that. I hit it, Zach. Sorry. Oh, another lightning strike. All right. So JWD says, okay, Psychosaurus, even if they find him guilty of first degree, then the next phase, can they still find him schizophrenia and can they still get him help? Like in my mind, I'm thinking first degree, that's it. He goes to jail, he goes to prison, that's it. No help for you. Is that, you can still get, okay, you can still get it on first degree. Okay, that does help me, which is why I would not be fit to be a juror on this case. All right, so thank you for that. Psychosaurus. So, okay, so you could still say he planned this, it was premeditated, he's first degree. All right. That does help. That does help. Thank you for answering that. Appreciate that. Zach, you've been fat shamed. Heavens to Betsy. It's up there on my phone, but not on your TV? Huh. I don't see it. I don't see anything about butts other than what Baca just posted. I see it right here. Singing the song. So I wonder if they know that. I wonder if they can say, okay, first degree, but we can still get him help. I wonder if they know that. I wonder, Baca, you're pushing the boundaries there. That would not be fair. Oh, here. I would want to be fair when deciding instead of feeling bad for him or not caring and just say, oh, well, too bad. Here's the hardest sentence. You would want to be fair when deciding instead of feeling bad for him. Yeah, well, isn't that, I think Judge said that. Don't feel sorry for anybody. I guess, are you not supposed to feel sorry for the victims, though? JWD, we talked about that. No, I think it's, you're asking, could they give half prison, half hospital? Psychosaurus, that would be one for you. I don't think they can split that time. I think it's one or the other. I think they either give him prison time with help in prison, or they give him hospital time, and he's probably never going to get out. I can't imagine he's going to get out with 2 deletions and 1 attempted. I don't think they would. I don't think they'd let him out. Just Shamrock. It's complicated. If the foreperson doesn't have a clear understanding of the current task and later secondary steps, they could be spinning down ways they don't need to. I know. Baka. Yeah, I can't believe with all this lightning going on, all this thunder, Paulie's pretty chill. Everybody's pretty chill. They all seem to be taking it in stride. So let me go back to this. Hannah, still no verdict. Nope, we're still waiting. Abe says he won't be out for the next 10 years no matter what. Yeah, no way. I don't think 10 years, Abe. I think it's going to be, I think it's going to be a lot longer than that. I mean, 2 people lost their lives. I think that should be 20 years at least for that alone, you know. I want to go back to this. Ida, if someone deletes another person but didn't know they were holding a knife or didn't understand what they were doing, they cannot be guilty of or even manslaughter. Well, they have to find him guilty of something. They can't give him a free pass, sadly. So it's got to be first, second, or manslaughter. It's got to be one of those. Those are the options. Brett says it would be dramatically less confusing if they just had 3 options: guilty, not guilty, reason of insanity. Curvial, how's it going? Good to see you. Thank you for joining us. That one got Paulie's attention. Here comes another one. Just saw the lightning. Ida says, because all homicide crimes require at least some level of awareness or intent. Kenneth, good to see you. Number 58. Thank you. Great seeing you. Greyhound got out in 10 years. Wow. Oh, Paulie heard that one. Yeah. We're a few seconds behind, but Paulie heard that one. Let's see. Irish Amy's saying hello to Kenneth. Always good to see you in our chat. 13th juror, still no verdict. Still no verdict. Oh, Paulie's doing something over there. Oh, this waiting is terrible. We got to figure out what we're going to do tomorrow. I think, I don't know. I have to talk to Aaron. Because we did Stearns today, which was really good. I thought for sure they'd have a verdict for Carlos so we could go straight into second phase. But we got to figure out what to do while they're still deliberating. Abe says, here in Canada, the maximum they could have gotten was 3 years, 2 of which would have been in community programs. That's just because they were children. Oh, you're talking about Slender Man? Oh. Baca says, Paulie's getting anxious now. Marty says she's bathing the kitties. I think so. Ida says, what name? I am from Poland. Missy, I was just about to ask what we're doing tomorrow. I know. I don't know. We got to figure that out. They went home, Dennis. They went home for the day, so no verdict over in Karen either. They went home for the day. So everybody's in verdict watch. Nothing new to report. It was a silent day. Everybody's in verdict watch right now. Had some more lightning coming in. The one in South Carolina starts. There's one in Connecticut too. I don't know. I don't know what to do. Because I don't want to start a new trial and then, I want to continue on with phase 2. I don't want to not continue on with this. I don't want to give up on this trial. So I don't want to start a trial and then just get into like opening statements and then we got to stop. Abe says the best verdict watches come with kittens. Yes. Baca says Karen Reed went 5 days before they declared. And they went to the judge at least once, right? And she read that Allen charge, or Ramirez. Was it Ramirez? Was that what it was for Boston, for Connecticut? Vera? I forget now. Yep, it was 20, something like that. Abe, it was long. Shirley saying, "Yep, Paulie, clean your babies." Irish Amy, any more verdict prep we could do for Stearns or Donna? Always. Yeah, there's definitely always more verdict prep for Stearns. Yeah, we may do that. There's so much phone calls out there from Stearns, and I reached out to one channel because they had like 3 hours of his phone calls, and we're waiting to hear back from them. Let's see. What did I say? Trial prep? Verdict prep? Sorry. I don't know what I said. Nanar, I left for a bit. Had a contractor over, so nothing yet. Yep, nothing yet. We could play catch up on South Carolina versus Jackson. That way we don't have to worry about being live like Monica in the beginning. We'll think about that. Holly, that's done all the time in true crime, starting another trial while on verdict watch for this one. Yes. But then this trial isn't just straight up verdict watch. This trial is going to go into phase 2, and so we'd have to completely stop whatever it is we were watching if we start another trial. And then we may not pick up on that for weeks or months. If this was just straight up guilty verdict like Karen Reed, I would probably start another trial. But this one is going into phase 2, so that's why I don't want to start another trial and then give up on that trial to continue on this phase 2. So that's why I'm hemming and hawing about starting another trial. Michelle, will you be notified when the verdict comes through? I know Friday you didn't even know the jury was out. Yep, until the end of the day. This is yep. Well, we're hoping that Newton will inform us. All right, we'll see. Yes, that is correct. The 23rd, actually. We have that as the 23rd. It's a Monday. So we have that as the 23rd. So next Monday is Monica's sentencing. So yeah, we're definitely going to cover that. In the meantime, we've got Kitty Watch. There you go. Baca says we're here. Brat says the internet was invented for kitty photos. True crime streams are just a side effect. Right? We have it as the 23rd, Monday. So we're pretty confident that it's the 23rd. That's what I have. Let's just double check before we go down a rabbit hole. Let me just double check. Sentencing June 23rd. So yes, June 23rd sentencing. Ida says, if it's true, then I'm not surprised there's no verdict. I wouldn't choose anything from those three either. I know, right? Ooh, let me go see. I'm going to go pet the kittens. Here, I'm going to go pet them. Hold on. I'll put some music on for you guys.
Y si tú me quieres, ven pa' aquí, te atreves. Dame esto lento, quiero sentir tu cuerpo. Volamos juntos, cuando estamos juntos. Ven pa' aquí, mi amor, hacemos el amor. El mundo se paró, solo esta pasión. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo y no me importa nada.
Trying, I thought you meant well, but you savage as hell. Telling me things we both know you regret. But that hill should've told me about her before you sucked me in. You thought we could be cool for the summer.
Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Aquí mi amor, hacemos el amor. El mundo se paró, solo esta pasión. Me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo y no me importa nada. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Somos el amor, el mundo se paró, solo esta pasión.
All right, I just called the courthouse, and they said they are still deliberating. So it's just 3 o'clock over there. Just hitting 3 o'clock California time. So I called the courthouse. They said they are still deliberating. So we wait. Let's go back to the music.
So take the first bus in the station. Everywhere is nowhere to lost souls. Let's get lost by intention. Where the world has protection. Where the waves hit the sand. Naked bodies in the sun, scattered lips, arms and pebbles, sinking slowly as the mud at the bottom of the ocean. We're all light and emotion. Drifting without a sound. Me and Mary and I walk into her room. Through lonely streets at night under blood cherry moon. Till we hit the ground. Lay upon a shallow part of the dreams, late in the morning. Smell of coffee and of silent fiends slowly are morphing. The recollections of drowning in each other's arms. Me and Mary and I walk into her room. Through those lonely streets at night under blood cherry moon. Till we hit the ground.
de palpitar, de palpitar. Mi amor es franco y fiel, no tiene fronteras y no maldad. Mi amor es franco y fiel, no tiene fronteras y no maldad. El río fluye, nunca solo está, no solo está. El río fluye, nunca solo está, no solo está. Franco y fiel, no tiene fronteras y no maldad. Mi amor es franco y fiel, no tiene fronteras y no maldad. El río fluye, nunca solo está, no solo está. El río fluye, nunca solo está. Solo
Y si tú me quieres, ven pa' aquí, te atreves. Dame esto lento, quiero sentir tu cuerpo. Volamos juntos, cuando estamos juntos. Ven pa' aquí, mi amor, hacemos el amor, el mundo se paró. Solo esta pasión. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo y no me importa nada.
You got a heart like a lion. You got me messed up without even trying. I thought you meant well, but you savage as hell. Telling me things we both know you regret. That hill should have told me about her before you sucked me in. You thought we could be cool for the summer.
Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Aquí mi amor, hacemos el amor, el mundo se paró. Solo esta pasión. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo y no me importa nada. Mira, me siento el calor de tu mira. Cuando estás acá estoy tranquila y no me importa nada. Fuego, yo siento contigo un fuego. Me mata el olor de tu cuerpo. Aquí mi amor, hacemos el amor, el mundo se paró. Solo esta pasión.
All right, everyone. I'm going to call it a night. Newton says they're still there, but it's 4 o'clock there. I have a feeling they're going to be going home soon. So we made a decision. There's a trial starting tomorrow that we're going to pick up on. It's Raoul Valley. I got to figure out how to pronounce his name. May 2022 offing of a Fairfield prep student, James McGrath. So Valley, 19, faces charges, 3 counts of first-degree assault and also deletion in a connection with a fight that's broke out in a house party. So he rejected a plea for 40 years, and he's out on $2 million bond. So we're going to pick up on that one tomorrow. Let me just see. There was during a fight. According to the affidavit, Valley had been at a party on Lazy Brook Road in Shelton with other students from Trumbull's St. Joseph High School. At some point, a group of students from Shelton High School arrived, and an altercation between the 2 groups of students took place. After the fight, some of the students went to another house party where the 2 groups continued bad-mouthing each other on a group chat. Valley and several other students then drove to Laurel Glen Drive, and another fight broke out. Several teens, including McGrath, were stabbed in the altercation. So, Golden Girl, that's your suggestion? All right, well, we're on it. There you go, Golden Girl. That's the one, and we're going to pick up on that. Widespread says, I will have to research that one unless you're planning to do the background on that one. Yeah, research all you want. Go for it. You know, we're doing ours, but please, yeah, get yourself versed in that one. Sinbad says you're interested in that one too. Golden Girl used to live there. All right. So it's starting tomorrow. We're not giving up on Carlos. Don't worry, we're not giving up on Carlos. We will definitely be covering Carlos. But what may happen is we'll do the East Coast one from like 9 until 4:30, whenever it ends, and then we'll pick up on Carlos. So we'll it'll be long days, but we're definitely going to continue on with Carlos. So let's see. Oh, Psychosaurus, you suggested it too in a slurry of other chats. I'm not sure it got missed. I had on my spreadsheet of court tracking for 2 years. Wow. All right. Good night, Capri. And you're welcome, Golden Girl. You're welcome, Psychosaurus Rex. And yeah. We'll see you guys tomorrow. Have a great evening. Thank you to Aaron. Thank you to our mod squad. Thank you to our newest mod, Irish Amy. Yes, Irish Amy is our newest mod. Be sure to thank her on your way out. I don't know why I have this on. It's not Stearns, it's Dominguez. I'll get my trials sorted out. Thank you to our newest mod, Irish Amy. Make sure you guys thank her on your way out. And thank you to all of our fantastic mod squad, and thank you to Aaron. Thank you to our chat for being with us. Really appreciate you guys, and we will see you tomorrow at 9. I believe it starts at 9. So we're going to pick up on Connecticut versus Valley. So have a good night, and we will see you tomorrow. Bye.
Mm-hmm.